Legal dictation exercise 99 start. Learned counsel for the appellants argued his case and submissions were made by him. Full stop. We may make it clear at the outset that none of the appellants belonged to the category of either SC/ST or ex-servicemen, and their claim is also not against these categories. Full stop. Hence, we consider it unnecessary to consider the validity of selection of the candidates made in these two categories. Full stop. In other words, we confine our consideration to the validity of section of the candidates made in the general category. Full stop. Mainly, the submissions made on behalf of the appellants were that after declaration of the result of the written examination on 1/4/1998, standard could not have been lowered for making other 40 candidates eligible for the purpose of interview, criteria could not have been framed after declaration of result of the written examination, maximum 21st candidates could have been called for interview in the ratio of 1/3 in the general category on the basis of the merit of the written examination, whereas out of 78 candidates whose result was declared on 1/4/1998, more than 60 candidates were from the general category. Full stop. Para. Learned Additional Solicitor General and Learned Senior Counsel for the respondents at the outset submitted that they have preliminary objection for the very entertaining of these appeals, and considering the contentions advanced on behalf of the appellants on merits having regard to their conduct. Full stop. According to them, the appellants made deliberate misrepresentation with regard to the allocation of marks, starting that 150 marks were for the written test and 100 marks for interview. Full stop. Further, malafides were attributed to authorities on the basis of the relation and political influence, which they gave it up before the High Court but again reiterated in the SLP. Full stop. According to the learned counsel, these two grounds are good enough to dismiss the appeals by revoking have leave granted without examining them on merits. Full stop. Although, we find justification in these submissions, but having heard the parties at length, we consider these appeals on the merits of the contentions as well. Full stop. On behalf of the respondents, further submissions were made explaining the criteria fixed, in what circumstances, more number of candidates were called for interview and how the selection made was fair and proper. Full stop. According to them, mere calling more number of candidates for interview did not vitiate the selection made having regard to the facts and circumstances of the case, at any rate, the appellants being lower in merit, even otherwise, could not get any benefit, full stop. According to the learned counsel for the respondents, the impugned judgment of the High Court is perfectly valid and justified, full stop. They also submitted that pursuant to the selection made, the selection non-official respondents have been continuing in service since May, 1998, that is, they are continuing in service for about 5 years by now, and as such these are not the fit cases for exercise of jurisdiction under Article 136 of the Constitution of India to interfere with the impugned judgment and order, full stop, para. From the chart extracted above in regard to the marks secured by the appellants and the respondents, it is evident that respondents numbers 4 to 7 were in the first list, that is, they were formed out of the 78 candidates, full stop. The appellants cannot make grievance as far as these candidates are concerned, in the sense that they were in the first list and not in the second list, so as to given them advantage, full stop. No doubt, respondent numbers 8 and 9 were called for interview in the second list out of 40 candidates, full stop. Admittedly, the marks secured by these respondents are more than any of the appellants in the general category, full stop. It is pointed out that the two candidates, namely Ramnath and Paramjit Singh, in general category called in the list of the interview, have secured more marks than all the appellants, full stop. Even if the respondents 8 and 9 were to be denied appointment on the ground that they were called for the interview in the second list, the position of the appellants could not improve, full stop.